Hey everyone, we're going to be live. People are going to start joining us soon, and Dan's going to join us soon for our third installment of Coffee with an Estate Lawyer. Excited to be talking about executors today, and I see Dan just joined. Dan will be popping in a sec. Hello everybody, I said. For some reason it's not connecting with Dan, but give it another second. Happy Friday. Happy Friday, everyone. Dan, I don't know if you can, oh, you can see Dan. I can't see Dan. So uh, maybe we'll restart this. We'll get Dan to join, and then we'll get started. All right, let's see if we can get him in here again. Oh, there we go. All right, now we're
Hello,
good.
hello.
I think the issue was the technical issue was on my end, but
Okay,
we got it all sorted out.
wonderful. How you doing?
Great. It's Friday. It's Friday, and it's time for coffee. So of course I'm great. How about you?
Also great. Second coffee of the day, and looking forward to getting started.
Awesome. So it is a couple of minutes after, so let's get started. And as always, more people will hop on as we go, and so we may as well just sort of start the discussion, kick it off. First question, mug. Did you bring a mug today?
I did. So I don't have very many mugs at home. So this is a Miami Heat mug. It's sort of a vintage mug. A friend of mine works for the NBA, and he got his hands on some vintage mugs. There were no Raptors, so I got a Heat one and a Bulls one, and so the Heat went to the finals this year. I figured I would bring out that mug. You? What do you got?
I have I have my Mandarin mug. I actually have two of these. I have one, and my wife has one, and we're not necessarily for or against Mandarin restaurant generally, but somebody, it was a friend of my wife's, her name is Michelle, and Michelle's friend once pointed out that Mandarin, if you sort of break up the word, it's M and Aaron, Arin, which is of course how I spell my name. So M and Aaron. So we've got a couple M and Aaron, otherwise known as Mandarin mugs, and that's what I have today. Um, okay, so now that we've got the important questions out of the way, we'll do some chatting about executors. I feel like this comes up a lot in the type of work we do now because I think we've mentioned this before. Like people have heard about wills, but nobody really knows what they are. Nobody really knows what's involved. And there's a lot of terms that get thrown around. And the reaction you get a lot of the time is, oh, yeah, I've heard of that, but I'm not really sure what it is. And I think executor is one of them. People talk about the executor of a will. And again, it's one of those phrases that most people have heard, but doesn't have a lot of meaning. So this week we're going to talk about what an executor is. Just a reminder, this is a part three, I guess the third installment of a series that Dan and I are doing called Coffee with an Estate Lawyer. And every week, we started it a couple weeks ago because November is Make a Will Month in Ontario. And so we started this as a way of hoping to teach people a little bit about estates and give them some tidbits and perhaps answer some questions that they had. So, we did some will myth busting. Last week we talked about guardians. And so this week we're going to talk about executors, and hopefully answer some questions that people have. So I always start off with like the most basic question, and I guess the most basic question here is, what is an executor?
It's a very good question. So an executor is the individual, or it can be a trust company, and we'll get into that in a little bit, but it's the person or persons that you name in your will that will be in charge of managing your estate and carrying out your wishes when you're gone. So it's the will, as we've said before, it's the document that you create during your lifetime to set out what you want to happen when you are gone. And the executor is the person or people that you are going to leave with the responsibility of making sure that everything that you've said in your will is done and gets carried out according to your wishes. So, sort of at its most basic, that is what the executor is. And sometimes there's some different words that people use to refer to an executor. You may see estate trustee, you may see the term personal representative, depending on which province you're in. In some cases, there might be some slight distinctions between those two words. It doesn't mean that all those words are interchangeable, but more often than not, sort of the executor, the person that you name, is also going to sort of play the role of estate trustee. So it's probably not worth getting too in the weeds, but just know that there are some different terms that refer to the person who's going to be in charge of managing your stuff.
Yeah, and I think for the most part, a lot of lawyers, us included, when we were practicing, we used them interchangeably. Um, so we'll probably do that in this discussion as well. Um, Here's an interesting question. If I don't have a will, so I haven't written a will that calls someone my executor. So does that mean I don't have an executor?
Well, it means that you don't get to decide who that person will be. And it means that someone needs to apply for that role. So someone is going to take on the role of managing your stuff after you're gone. But if you haven't decided who that's going to be, it means that sort of anyone in your life that is willing to needs to step up and apply to court to be named the person who's in charge for doing all of that. And so there's an added cost to that. There's some delays, there's additional time that it's going to take for that process to play out of the court making that decision. Whereas if you had named an executor in your will, then it's a much more straightforward process.
Yeah, and there's a hierarchy about sort of who can and should apply and who will be awarded, but you're absolutely right. I mean, if you it's sort of an easy complication to avoid, and it's actually like one of the first lines of the will before you get into any of the other stuff we've talked about, like who the guardians are, or who's getting your assets, and what kind of charitable gifts you want to give. It's really like it's like the second line of the will that says this is who my executor is going to be. So it's a really important role.
Yeah, and we had a conversation with someone who was telling us that her mother passed away and didn't have a will, and she applied to be the executor, and she said sort of the process of being named executor, it was about 9 months to get to the point that she would have been at immediately had there been a will and had she been named. So a lot of delay, added cost, stress. There's a number of negative consequences with not having a will for sure, and then naming an executor being a big part of that.
Yeah, and on the cost side, law firms for the most part are used to seeing people come in applying for probate, and we'll talk about that. But basically, people sort of wanting to be confirmed as the executor when there is a will, and those are relatively straightforward court applications. But once you come to a law firm and there is no will, they're sort of forced to do something they're not necessarily seeing on a day-to-day basis, which means more time from the lawyer's end to sort of caught up to speed and reach out to the appropriate people and make sure that the applications are all getting incorrect. And exactly as you said, it's more time. In the end of the day, it's more costs. And the worst part about it is that like everything is frozen until that process is complete. So yes, allowances could be made to pay bills and of course like take care of children if that's something that has to be done. But for the most part, like you can't really get the wheels moving until there's an executor. So get a will.
Okay, so now that we've sort of done the high level explanation of what is an executor and a little bit about what they do, maybe we should get a little bit more into the details, more around what their actual responsibilities include. And so there will be some responsibilities that are immediate. There's some things that'll take place sort of a few days later, then maybe a few weeks later. So I'm wondering if you could speak a little bit to what some of those roles and responsibilities are, and a little bit about sort of the order in which they come.
Sure. So I guess what I'll start by saying is that there are a lot of responsibilities. It's not a small job. It's not a, the when it came to sort of the whole role as executor, when I was practicing, without fail, clients would come in after somebody had passed away, and the assumption is that an estate gets wrapped up in a matter of weeks, maybe a couple months at most. I mean, it's not necessarily a small job. There's bigger estates and smaller estates, but it is a pretty significant role. And it all starts with sort of what happens shortly after somebody passes away, right? And so the things that the executor needs to turn his or her mind to is planning the funeral and or whatever arrangements the deceased wanted, because a lot of times people will express those wishes while they're alive. This is the type of service that I want. I want to be buried versus cremated. If I'm going to be buried, this is where I want to be buried, or I've already purchased a burial plot. If you want to be cremated, what's to be done with the ashes. There's wishes around organ donation that people have and often express during their lifetimes. So the first thing that an executor needs to turn their mind to are there any wishes like that? And if so, how do I go about fulfilling them? One of the things that I always told people, I know you did the same thing, is people like to put those wishes in their will, but I think we've said before that oftentimes the will isn't even found until a long time later. It could be days or weeks after somebody passes away that you can finally sort of track down the will, because you generally need an original copy of it. And so it's these types of wishes that if somebody has, we always recommend you express them to somebody during your lifetime. And so if you've expressed those to your executor, their first act is to sort of start carrying out those wishes.
Yeah, absolutely. And there are, as you suggested, there are some things that get done immediately. So, planning the funeral and making certain arrangements, and then there's some things that'll happen sort of in that next step. So that's canceling credit cards and utilities and things of that nature. Payments that don't need to continue to be made. Conversely, making sure that you are making the payments that do need to continue to be made. Locating all of the assets, sort of notionally bringing them in to the estate to understand what's comprised. Are there any debts and mortgages and liabilities that we need to consider? Making sure that taxes are being paid, and so that might mean speaking to a lawyer, accountant, another professional to prepare final tax returns and things of that nature. So, as you mentioned, this is not a small job. One of the important things to note is that your executor doesn't have to do it alone, in the sense that they can get help from professionals. And often there's an explicit provision in the will that says, I want my executor to know that they can go out and seek the help of professional advisors on certain tasks to make sure that those things get done correctly.
Yep. Just some of the other things I'll mention, and again, this is really just, the tip of the iceberg, right? So, think about the person's home, right? So if they live there with a partner, and, again, you've been named the executor of the estate, you may not need to do anything there. Maybe the house was in both names, held jointly in both names, and now the spouse is just, now the house is just in the name of the surviving spouse. But what if the house was in just the individual's name? What if they live there on their own? Well, is there anybody still living there? Are there kids living there, either young or older? Is there nobody living there? In which case, as an executor, you have a responsibility to make sure that the house is secure, that nobody's going to break into it, or that you have the keys to get into the house if you need to. Another thing that goes hand in hand with the house is insurance. So even if the house was held in joint names, well, the insurance might have been under joint names. And if the house is now under an individual's name, the insurance might also have to be under just that individual's name. So it's important to contact the insurance company. If the person was receiving government benefits like CPP or OAS, well, those and there's a lag between when a person passes away and when those programs will actually get notice. So they'll actually keep sending the checks or doing the direct deposits into that account, but those benefits are really supposed to stop the day a person passes away. And so the sooner that the executor can contact those programs and say, hey, stop the payments, the better, because otherwise you're going to have to repay those things down the road. A lot of people don't know this, but the government offers a death benefit. So if you've been sort of paying into a program, I think it's if you've been paying into the CPP program, you're eligible for a government death benefit. I think right now it's about $2,500. And so the executor has a responsibility to apply for that benefit. And it's not a difficult thing to do, but it could certainly help defray things like funeral expenses. And so again, just another thing to add to the list. And again, those are the things that are happening in the next few days. Bigger jobs will be, as Daniel mentioned, collecting all the assets, figuring out what did this person own, because the will is going to say, collect everything I own, figure out how much I have to pay in taxes, and then whatever's left over, that's what you're going to distribute according to the will. And then one last piece, and this is sort of like the big variable, is like, how long does this take? Like, how long can it take to distribute an estate and sort of wind everything up?
Yeah, so I mean, there's a term out there called the executor's year, and that's a common law rule that suggests that within 1 year, the executor should be in a position to start distributing assets to beneficiaries. And if it goes beyond that year, then there's an opportunity for beneficiaries to go to court and say there's been delay here, and we want our distributions. So the rule is flexible, it's not written in stone, and it's meant to apply to simple estates and more basic estates where the belief is that it can be dealt with within a year, but that's not always the case. And so if this is a complicated estate, if there is fighting between beneficiaries, if there are issues that sort of create a situation, that means that it might take more than a year, then it might take more than a year. But as a good rule of thumb for something that is simple and basic, the thought is that it can be sort of dealt with in a year. But as you said, oftentimes people are expecting this to take weeks or months, and this rule says you've got up to a year. So there's a sort of a difference there between what people might expect and what the reality is.
Yep, and there's also trusts, right? So you might have, let's say, for example, you have two kids that are over the age of 18 and one kid that's under the age of 18, and your will says, okay, if somebody's over the age of 18, they can get their inheritance right away. And if somebody's under the age of 18, then, well, they got to wait till they're 18. You can't pay it out till they're 18. So in that case, you're going to have a component of the estate that you could pay out right away. And when I say right away, I don't mean, in the days or weeks after somebody passes away. I mean, once you've done all this administration and collected all the assets and made provision for the taxes, I mean, that's going to take time. And like you said, somebody has up to a year to do that. Beyond that year, or once you get to that year mark, there's sort of an expectation that there should be the ability to pay out those beneficiaries who are over the age of majority. But the beneficiary that's under the age of majority, I mean, if there's provisions in the will that says hold part of that share of my estate in trust for them until they turn 18, well, you're not paying that out within a year. That could go on for multiple years. And often, the age that people specify in their will isn't 18, it could be 25 or 40. And so a lot of times, in fact, in most instances, the terms of the will itself necessitate that there is an administration that goes beyond a year, and all the executor is doing is following the instructions that are given to them in the will.
Yeah, that's a very good point for people to hear and understand that to some extent, as the person making the will, you have a little bit of, or not a little bit, you've got a lot of choice in how long the administration could take. And so if you choose that a minor shouldn't receive their inheritance until they turn 40, and you're talking about a newborn, then that means that the responsibility of the executor, of the person who's the trustee of that trust, um, might be administering that for 40 years. And so it's something to keep in mind.
Okay, so this is a big role. It's not. There's a lot to do. There's a lot to be on top of. The question is, how do you decide who the right person is for this job, right? Like, is there one right answer to the question of who should be my executor?
So there's no one right answer, but there are certain things that people should think about when making this decision. As we've said, it's a big job. There's a lot of responsibility, and it's going to be very important to choose someone you trust. And that doesn't mean that it's always going to be, a spouse or a parent or a sibling or a friend, but it means that sort of for each individual person, you need to look at your circumstances and your relationships. And by doing that, try to pick the person that you think could handle this role, understanding that they can get help if they need it, but the person who is capable of handling the responsibility that you are giving to them. And some of that's going to have to do with some of the decisions that you make in your will. So if someone is married with no kids, for example, and in their will they've chosen to leave everything that they have to their spouse, well, it might make sense then to name their spouse as either the executor or one of the executors on the basis that sort of the entirety of the estate is going to end up in their hands. If someone is single and they are distributing things among a lot of different people, then they're going to have to make some decisions about who in their life do they think manage that role. So it is challenging to make that decision. There's no question. It's one of the biggest decisions that you're going to make, but you should do it based on trust and who you think would be able to step into that role in a way that they could sort of do the job that you would hope that they could do.
Yeah, and in addition to being able to sort of having the capacity to do this type of work or to manage this type of project, because that's really what it is. You touched on this before. Are you going to name a parent when the beneficiaries are your children, right? So if something happens to you, 20 years down the road and your parents are in their 80s and your children are still minors, and you want to have stuff held in trust for them until they're 35 or 40 years old, is your parent the right choice? Because odds are they're not going to be able to see that administration all the way through. I think you touched on this in your last answer, but one of the questions we get a lot is, okay, so if I name somebody as an executor, can that person also be a beneficiary of my estate? Can the same person have this role as executor to be in charge of everything, but also be a recipient of some of my assets under the will?
Yeah, and that's a question that we get a lot, and the answer is yes. And in fact, it's quite common. When I was practicing, I would say certainly the majority of wills that I did, the person who was named as the executor was also the beneficiary, and that happens with family, right? So if you're naming your spouse to be the executor and your spouse is also a beneficiary under your will, that makes sense, both from a distribution standpoint and picking the person that you want to be the executor. So the same rationale goes if you have adult children. So children that are old enough that they can sort of be an executor, they're above the age of majority, and not just the age of majority, but also it's important to know that sort of they've got the capacity, as you said, to handle that role. But also adult children are going to be beneficiaries under your will. You're going to leave stuff to them. And so, the answer is yes, an executor can and often is also named a beneficiary.
And one of the other questions that we get is sort of the opposite end of the spectrum, where people say there's really there's either nobody who's close to me, nobody in my family or none of my friends who I feel confident can do this job. It sounds like a big job, and it is a big job. I don't want to necessarily burden somebody with this, I'm giving a lot of my assets to charity, and this person won't necessarily know how to deal with all of these charities. So one of the things that we get asked about is corporate executors and what that means to name a corporate executor or a corporate trustee.
Yeah, so that's also a good question, and I think it seems that now there are, there's been articles that I've seen lately in videos, and this discussion about corporate executors is one that is not to say picking up steam, but maybe becoming more prevalent now. And so, as you said, if someone doesn't know who to name for that job, or they don't have someone in their life that they think could handle that role, there is another option, and that option is a professional executor, often in the form of a trust company. The advantage of a trust company is that it doesn't die, right? Sort of simply put, in the way that an individual could. And so, as we were saying before, if you have money that's being held in trust for a minor until they turn 35, so that could be 35 years of someone being in the role of executor, or trust that trust. And so, by naming a company, you make sure that there's continuity there, so that role is always being filled appropriately. A couple things to note when it comes to corporate executors is the fees. So, of course, they charge to do that work. The fees are going to be different across different corporate executors. So if you bank with one particular bank, and that bank offers trust services, it's important to start that conversation with the bank or with the trust company to understand, as a starting point, are they willing to act? Because they've got certain requirements about when they will act in that role. What are the fees? Is it reasonable for you based on the size of your estate and the complexity and what you are needing out of that relationship, to understand what that is going to be, and then to walk down that road to understand if that's something that, sort of, now that you have all the facts, maybe you look back and say, okay, so now that I understand what the fees are, do I think there's someone in my life? Do I think there's an individual that maybe would be suited for the role instead? Or does it make you even more confident to say, what, this is exactly what I want, and this is money that I'm happy to go to that trust company on the basis that they will do a good job, and this is something that they're comfortable with, and they're not grieving. And so there's a lot of considerations there when it comes to corporate executors.
Yep, and I think, at this point, it's also worth mentioning an executor at law, generally speaking, is entitled to compensation. Even if the will doesn't say anything about compensation, if the will does talk about compensation, then it's basically whatever the will says. So a will could say no compensation, or it could specify compensation based on a percentage of the estate, or a dollar amount, or an hourly rate for an executor, but it doesn't have to. And even if the will is silent, then there are sort of general rules that the courts follow when awarding compensation to a trustee. But in cases, a sort of a simple case where a spouse is inheriting an entire estate, and he or she is also acting as the executor, there's no reason for them to claim compensation because they're getting the whole estate anyways. And often in close family situations, you don't see anybody claiming the estate because it's all in the family, as they say.
For sure. So I see we're running up on time, but I want to ask you one more question, because this is a question that we got asked in practice a lot. And I think it's a good one. And it's probably one that we answered last week as well when it came to guardians, which is, if I name an executor in my will, should I tell them that I've named them? Should I have a conversation with them before I name them? What's the advice that you gave in practice? What's the advice that you would give someone now about, sort of, if and when to let someone know that you'd like them to act as executor?
So, I would say the best time to have the conversation is before you've created your will. Because if you create your will and then call up the person or get them into a Zoom meeting and say, oh, by the way, I've named you as the executor of my estate. Well, they don't necessarily know what that means. They don't necessarily know if they're up for the role. And if they're not, hopefully they tell you that. Hopefully they don't just sort of keep it to themselves. But if they do tell you that, then you're in a position where you actually have to go and redo the will and name somebody else. So the best time to have the conversation is before you actually go ahead and create the will. And you can, we have on the Epilogue website a piece on executors where we have sort of a very basic checklist which talks about some of the responsibilities of an executor and some of the things that an executor would need to know in order to sort of know enough to say that they're willing to take on that role. And so you have that discussion with them, and then you go ahead and create your will and you name an executor. And just like with guardians, like we talked about last week, more often than not, there's an alternate executor, so something that says, okay, in case this person is either not alive or not capable or not willing to take on that responsibility, then I name this person as my backup executor, so to speak. But always important to have the conversation before. That being said, there's no requirement to, right? And so, there's no explicit requirement for the executor or the person that's named in the will as the executor to also sign the will. They don't need to acknowledge it. And so more often than not, what happens is somebody does the will without having that discussion, and they name someone who they assume is going to do a good job and be a good executor, and they may or may not ever tell that person. And in those circumstances, the person finds out when that person who made the will passes away, and somebody eventually finds the will and calls the person up and says, oh, by the way, you were named as the executor and you have all these responsibilities now.
Yeah, and that's a phone call to get, especially if you're not expecting it. So, yeah, I think that there are people are hesitant to talk about all of this stuff. There's no question, and so sometimes it just feels easier to not bring it up because it feels like it's going to be a weighty conversation. But I do think it's important to have that conversation, to know that someone's willing to act in that capacity. It doesn't need to be a long, drawn-out conversation about necessarily everything that's involved. It's just to let someone know that this is what you are thinking, and would they be open to that? And it's wise to have that conversation now, because if someone says no, I have no interest in that, as you said, then you can have that conversation with someone else to figure out who is the right person and who's willing to take on this job. And if there is no one who's willing to take on this job, then maybe a corporate trustee is the way to go. Now that you understand that the individuals in your life who you may have wanted to take the job are not willing to. And so it allows you to sort of fully explore this conversation when you're in the best position to do so.
So I think we're at time, and I don't want to steal any more time from anyone else's Friday, but there is a whole other discussion that we were going to have about another one of those words that people hear when it comes to estates, but they don't really know what it means, and that term is probate. But what I think we'll do is we'll save that discussion for another day, because I'm sure that we could have a full coffee with an estate lawyer discussion one day about what it means to probate a will and what the executor's role is in that. Does that sound all right?
I think that's the right decision.
All right, awesome. Well, this is great. I'm going to grab my mug. I don't think I drank much during this coffee with an estate lawyer, so I'll take one sip now and say thanks to everyone for watching. And we'll be back next week with another edition of Coffee with an Estate Lawyer for Make a Will Month in Ontario.
Great. Thanks so much. Bye, everybody.
Thanks, everyone.